40-year fitness is in histrionics over he learned a little bit today and now it's scaring the hell out of him. And I don't want everybody to be scared. So I'm going to try to help everybody realize that nothing's changed from yesterday. And there are lots of reasons why things are the way they are. And there are multiple protections for you. So relax, take a breath, and let's go through this a little bit. First of all, for 200 years, no man ever thought of reasonable suspicion. Just one court did. 9 men created something that wasn't intended by the Constitution or by any federal or state legislator. He's wrong. And he's wrong for the reasons that I laid out here. But I'm going to go over them with you. The first thing is the Fourth Amendment. The Fourth Amendment only applies to the federal government. It only applies to the federal government. It does not protect you from the states. And there's a reason why it didn't have to protect you from the states for hundreds of years. But it doesn't. It only protects you from the federal government. And it protects you from unreasonable searches and seizures. So if a search is reasonable, the Fourth Amendment applies no pressure. It's not designed to protect you against reasonable searches or reasonable seizures. It's designed to protect you against unreasonable searches and unreasonable seizures. So it's not something new. It's right there in the Fourth Amendment. That's what the Fourth Amendment is designed to protect you from. Unreasonable searches and seizures by the federal government. Now, after the Civil War, during the Civil War, it came to the attention of the North that the South wasn't, and wouldn't protect its newly freed black citizens. The newly freed slaves. They were basically left to their own devices. They were still considered less than citizens, and that was not an acceptable situation. So they ratified the 14th Amendment. And the meat and potatoes of the 14th Amendment, at least for our purposes today, again, this is just one small section of it, so I'm not going over the whole 14th Amendment, so relax. But the meat and potatoes of it is that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Eventually, this came to mean that the Fourth Amendment could and would and did apply to state action, not just federal action. So the Fourth Amendment applies to the states through the 14th Amendment. But that didn't happen quickly. It happened in Mapp v. Ohio in 1961. The police, I don't know if they actually had a warrant. They said they did. I don't remember. But they broke into Mapp's house looking for porn, and they wouldn't show her the warrant, and I don't think they had one. Doesn't really matter. But at the end of the day, it got to the U.S. Supreme Court, and the U.S. Supreme Court said, no, the Fourth Amendment applies. You can't use evidence that you have obtained in violation of the Fourth Amendment to convict her. Because I believe Mapp was a female, but I'm pretty sure Mapp was female. Yeah, in her possession. Yeah. That's a weird one, but porn's been around forever. Mrs. Mapp was a freak! Or Miss Mapp, I don't know. Whatever. So that was in 1961. So the country had been around for about 200 years before the Fourth Amendment applied to the states. And then in 1968, we get Terry v. Ohio. And I think the reason why is because Mapp v. Ohio said, hey, by the way, if something violates the Fourth Amendment, you can suppress it. And Terry had a gun under his or in his pocket, and Officer McFadden thought he was going to be doing armed robbery So Officer McFadden, acting on his reasonable suspicion, which means reasonable articulable suspicion, which means reasonable suspicion that a crime is, was, or has been committed, and there is not just the officer's inchoate hunch, but there's also some articulable objective fact, etc., which normal rational people call reasonable suspicion. Instead of saying all those things, you could just say reasonable suspicion. But reasonable suspicion isn't a concept that the federal government had dealt with yet. It isn't a concept that had made it into federal case law. Because the feds don't patrol beats. They're not beat cops. You know, the FBI, they don't just patrol city streets waiting for crime to happen. They get reports of a crime that's been committed, and then they go and they investigate it. So this is new. This is a groundbreaking territory for the federal government, but it's something that has been going on in the state government forever and a day. So in Terry v. Ohio, the court looked at it and they said, you know what? That search wasn't unreasonable. It was a reasonable search to pat down when they balanced the dangers to Officer McFadden and the interests of the state and the intrusion into the privacy of Terry. They said this search was reasonable. Now, if he'd gone into, if he like did a strip search or something, that wouldn't be reasonable. And all of a sudden the Fourth Amendment protections would kick in. And they're not saying that Terry could then, pop a cap in Officer McFadden's ass, but that would mean that Terry could get that evidence suppressed from the trial. And Terry could also then theoretically sue under 18 U.S.C. 1983 or something along those lines. But for 200 years, there was an alternative. For 200 years, they didn't think of going to the federal level because there are state constitutions. And those state constitutions typically have things in them like searches and seizures. The people shall be secure in their persons, houses, papers, and possessions from all unreasonable searches or seizures, and no warrant to search any place or to seize any person or thing shall issue without describing them as near as may be, nor without probable cause, supported by oath or affirmation. Doesn't that look a lot like this right here? This was Texas's, by the way, but you could pick a different state. I just picked Texas because I do a lot of Texas stuff. I could do California too. But the point is that the states provide you with protection. And so for 200 years, the reason why it took until 1961 was because the states had been applying the same or better protection to the people. And it wasn't until in this one, I believe the Ohio Supreme Court. Yeah, so this went all the way up to the Supreme Court of Ohio. And the Supreme Court of Ohio found that her conviction was valid. And that's why the U.S. Supreme Court looked at it. They're like, well, no. You're going beyond what the 14th Amendment is going to allow you to do. So we need to step you back a notch. Because the Fourth Amendment sets the floor. A state can give you more protection than the Fourth Amendment, but they can't give you less. And in Mapp v. Ohio, they were giving Mapp less protection than the Fourth Amendment, which was abridging the privileges or immunities of the citizens of the United States. So that's how we got to where we are today. It's not the Supreme Court didn't make reasonable suspicion. They codified kind of how they're going to determine it, but forever and a day, officers on patrols have been detaining people to inquire about their comings and goings and whether or not they're involved in crime. And then the federal Supreme Court said they can do that. They can continue to do that as long as it is reasonable. That's it. So I hope this helps. I know we're kind of going over this a lot, but it seems to be catching a lot of attention, and it seems like a lot of people have issues with it. But remember, your remedy is going to be a federal lawsuit or getting the FBI to investigate the situation to see if the police are in violation of 18 USC 241 or 242. So thank you for watching. I hope this helps. My bill will be in the mail. You can all pay it however you see fit, preferably in G strings. Thanks for watching. Have a great day.